it's useful to understand this hierarchy because it tells you where things are coming from and where things are going, and when something is, a little bit shady legally, because a lot of the times what happens in environmental law, as Arpita was saying, was that a lot of stuff happens at this level of circulars and notifications, as you were seeing. And then you sort of have judgments, you have the court coming in at that level. So at least for the entirety of the coastal space, the Environment Protection Act is almost never touched as an act. The Constitution sometimes does get touched. Supreme Court comes in, and then there's all of these notification circulars and all of these things, which is where the entirety of the governance sort of happens. So just to quickly do a little bit more of what are the rest of the jigsaw puzzles. The other part of it is the backstory, which is also like, so the first notification we have is the CRZ 1991, but there's also a lot of both political and legal things that have happened before 1991, which govern what is happening in 1991, between 1991 and 2011, when we have 2015, when this notification is there. We have the Stockholm Conference, which is an environmental conference which started talking about, we need to protect the environment. We have 48A and 51AG came in which only were included in the Constitution in 1976 as a constitutional amendment. In 1981, so again, this is where law sort of gets made from all kinds of places. And the 1981 is sort of like the place where the CRZ started, because Indira Gandhi went to Goa and she saw like a very crowded beach, which was full of pollution because tourism had started taking on around that time in Goa. And she got really upset and she wrote to all of the chief ministers of the coastal states saying, what is going on? Why is there so much pollution on the coast? We need to protect the coast, etc., etc. And also for the Lakshadweep, because the Lakshadweep used to be quite a pet destination for the Gandhis. So once this letter gets written, there's suddenly a host of, I've not put it here, actually, I missed this, but a couple of years after that, you had what were called the beach guidelines, which were like the first sort of official anything on coastal governance that came out at all. Between 1980 and 1986, again, there were a whole host of environmental law cases that were happening where the right to environment was read in as a fundamental right under Article 21, which is the right to life. So the right to a clean and healthy environment, a lot of, environmental law sort of got subsumed under Article 21. And so this is the whole context in which 1991 May, the CRZ notification happens and all of the rest of the story that we've looked at. And also the last bit of the puzzle, which is that this notification and this particular act and all of what we looked at also sits, Arpi, if you go next, within a frame of a whole bunch of other acts, other notifications, other constitutional principles, everything else that happens, all of which exists in the exact same space. So in the Lakshadweep, there is this notification, there are the integrated island management plans, there is the IPZ notification of 2011, but there's also the Biodiversity Act, there's also the Wildlife Protection Act, there's also like the Lakshadweep Fisheries Regulation Act. So there's a whole bunch of other things that exist. And we'll get into this more going forward into how a lot of this sort of also interacts with each other. I just want to give you two examples of, just two places. So I want to go back to this idea of the sources of law and where does law come from and where does law not come from. There are two examples I want to give you. One is in Rameshwaram, where you will see the video later and you'll understand what is happening. It's seaweed collection that happens. And there's a bunch of norms that the seaweed collectors have created together. Some of those norms are written there on the side. And these norms are a union resolution. They've gotten international awards for being, eco-friendly and all of that stuff. And on the next slide, we have a another community-based sort of norm making that happened, which is for something called fish aggregation. And here again, there are a bunch of norms that the community came up with, which are there on the slide. And this was made into a panchayat resolution, and the panchayat resolution was then given to the fisheries department, which then circulates it annually as a like circular or an order of the fisheries department. So I just wanted you guys to think a little bit about two very similar situations of norms created by the community, and to think about what do you think is law from both of these. Are both of these law? Is one of them considered a law? Is one of them not considered a law? Does one of them seem more valid legally than the other? So that's just where I was going for. And that's it from me. I'm going to give it back to Arpita. And thanks a lot, you guys.
Thank you so much, Stella. So before we kind of get into the component of interpretation, I just want to quickly summarize a couple of the points as we went through the notifications themselves. And I think it becomes important to speak about this a bit explicitly. One is that as much as the law seeks to decide the sources of law and what enters into the realm of law, it is as much an activity of norm creation and customary sources that gain formal recognition. So what do I mean by that? So like the example that Stella gave, if a particular panchayat resolution is solving a problem on the ground, it may or may not penetrate into the discourse of the formal law, although it comes from a panchayat, which is a structure derived from a formal legal source like the Constitution. So why does that happen? That's a pretty political act. There's, Duncan Kennedy, who is a critical legal theorist, argues about how the sort of the art and process of formal law, how it expands and creates and duplicates itself, is actually a product of convenience, right? Anything that sort of shakes the foundation of the Constitution, shakes the foundation of some of the formal legal structures, becomes an inconvenient outlier, which then if it gets incorporated into jurisprudence or law, becomes progressive or landmark, right? If you look at the Niyamgiri judgment. So always be careful about where does a certain normative structure come from and how much does it actually get recognized in the formal law, and whether it impacts state practice in terms of how the state and the bureaucracy functions, because that's where the real impact situation lies. And I think more and more people working on environmental law, if they're mindful of this, will start to see how much of exciting normative options get excluded and completely washed away because it's inconvenient. So quickly now to the interpretation, right? So we divided this particular workshop into sources, interpretation, and jurisdiction. So now you have a sense of where the law comes from and what the law does. But largely the law in terms of how it expands and, the law is a bit of an organism, right? So it starts to recreate itself. It starts to reinvent itself in many ways as a structure of rules, not just norms, but as a structure of regulating a lot of activities when it comes to the environment. But the power to interpret law rests in a few institutions. So the courts, for example, have a lot of power of interpretation. Why does interpretation become important? Because you have a set of rules, then you perhaps have a legal conflict to which the rules have to be applied. Now, how do the rules get applied? How do we understand this legal conflict? And that's where jurists and judges come into play. And they play a very important role. They build interpretive bridges between the statutes and the legal conflicts on the ground. But with environmental law, we can't isolate the role of courts. We have to move beyond the courts to look at administrative bureaucracy. Sorry, I was going to say units, but administrative units, bureaucratic bodies as well as what famous regulatory theorist John Braithwaite calls the street bureaucrats, which is your block development officer who's working on the ground. They become certain interpreters of the law. So it's an entire community of interpreters who start to decide what the law is and how it gets implemented. And the way they do it is by either creating notifications, letters, and all of it. I think a great read is actually to look at Paper Tiger, which I have a copy of right here actually, by Nayanika Mathur. It's a great book because it talks about the bureaucracy and how it creates law. So something to look up and something to read to understand where the law lies. So it's both sources and interpretation. I just want to quickly conclude with what influences and informs interpretation in environmental law. I think many of you must have encountered in your news articles and scholarship as well, this barrage of writing of ease of doing business, dilution of environmental law. Well, that's a very convenient juxtaposition. But actually, if you unpack the ease of doing business argument, you start to see that there's a certain political economy behind it. And there's a really great book called Code of Capital, in which I'm forgetting the author's name, Katharina Pistor, makes the argument of how law has been crafted to allow capital to thrive and survive and multiply, right? So in some sense, interpretation and how the law gets created is informed by the demands of capital. So ease of doing business is one way to articulate it. But if you start looking at subordinate legislation and environmental law, you will see how interpretive exercises happen to facilitate capital. And lastly, to conclude that the influence is not often only negative, which is political economy and capital. It's also positive, right? Social movements, progressive changes demanded by certain realities of the climate crisis. So that also informs and influences interpretation. To give you sort of a recent example, the German Constitutional Court came out with a judgment on the right of future generations. That was read into the right to life. So in some sense, because of the climate crisis, it sort of the interpretive exercise in the courts extended its understanding of right to life to incorporate these considerations of future generations. I want to stop with that. While you have these external influences of power and political economy shaping interpretation, the law again decides to organize this with general principles of interpretation. So over to you, Shrishti.
Thank you, Arpita. That was an excellent overview. And I think the way we'll do this is I'll just tell you to keep switching slides. Is that okay? Yeah. So my task here, I think, is fairly simple. When you have a law in front of you, what are some of the things that you should keep in mind in reading that law? And what I request you to do is to, I know Arpita shared the NGT Act with you. So if you could keep a copy of the NGT Act with you while we discuss the general principles of interpretation. And now, yes, it is the job of courts to interpret the law, certainly. And I think we've also talked about how citizens sometimes take ownership of these concepts. And I think that that in a way happens very often because in my head, at least, interpretation is really the act of persuasion, right? So you have a certain way of looking at the law. You think that this particular word means a certain thing. And once that idea is put persuasively enough, or say it finds its way before a court that accepts it, it can have very radical implications. And I think not in the context of environment, but in the constitutional context, like one question that people asked, which was a very compelling question, was that how do you interpret the word amendment? Does the power to amend the Constitution include the power to destroy the Constitution that gave you that power, right? So can you destroy the thing that gives you the power to amend it? And that sort of, obviously, there are many ways to which people arrived at the basic structure doctrine, and that's completely beyond the scope of what we're doing now. But it was a very compelling question of interpretation. Now, so when we are reading the law, I think the first thing that we need to keep in mind is what is the text of the law saying, or what is the plain meaning indicated by the text of the law. And when you're able to base your argument or your interpretation in this, I think you have a very high chance of persuading your audience, right? And I mean, that's also the first level at which interpretation takes place. So when the text of the statute is clear, nobody is going to go beyond it and add things to it or subtract things for it. Sorry, is anyone saying something? Okay. And then the next level is when there is ambiguity in the plain meaning. And a question you could ask is, why would there ever be ambiguity in the plain meaning of the statute? Doesn't the parliament know what it's doing? But just as we saw with the word forest, words can mean different things in different contexts. They can be understood differently. So then what are you supposed to do? You're supposed to look at the context of the statute, or the purpose of the statute, or the mischief sought to be remedied. And so if Arpita, you could go to the next slide. In the environmental context, I think the Godavarman case is an excellent example of this interpretive exercise. And this case has been critiqued on many fronts. I mean, even the interpretation, as Arpita mentioned, that it in a sense reduced a forest to its dictionary meaning. But in the perhaps what the judges thought they were doing was also expanded the meaning of the forest from just something that is recorded as a forest or that has been notified as a protected forest or reserve forest. They in fact said, hey, if it looks like a forest, or if it can be understood in terms of the dictionary meaning to be a forest, then looking at the purpose of the Forest Conservation Act and the, in a sense, a mischief sought to be remedied by the Forest Conservation Act, we will arrive at this broader, more liberal definition. So whether we agree with the court's approach or not, it is a definition that has really completely changed the landscape of Indian environmental law, right? And that is where the power of interpretation or putting across your ideas lies. If you could go to the next slide, I think we won't spend more time on Godavarman. If we yeah. So again, this is really the mechanics of reading the law, right? You should read the law as a whole. And I think one particular habit that we shouldn't do is to cherry pick provisions, try to understand the meaning. So what comes before it, what comes after it. And it's also good to be mindful of what the law was before. So it's interesting. So if the legislature knew what the law was before, they obviously intended to do something different. And that's how you understand what color or what meaning the law as it exists today would take. Now, when you're reading any law, you should be cognizant of something called a non-obstante clause, right? So if you look at the NGT Act that's there with you, section 33 is a non-obstante clause of sorts, right? So it says, the provisions of this act shall have effect notwithstanding anything inconsistent in any other law for the time being in force, or in any instrument having effect by virtue of any law other than this act. Now, there will be quagmires you'll get into sometimes where there are two legislations with non-obstante clauses, right? Then what prevails? Does the prior in time prevail? Does the later in time prevail? Does the general prevail, or does the special prevail? So, I mean, again, all of this will depend on the context, but generally the later in time should prevail because the parliament was should be assumed to be cognizant of what happened prior in time, and then special prevails over general. But these are all obviously very dependent on the facts of what is before you. Other words that you should be mindful of are subject to the provisions of, without prejudice to, and shades of meaning in may and shall, right? So shall indicates something that is directory, right? You have to do it. May give some level of discretion, but again, there are contexts in which a may can be interpreted to be a shall, and also be cognizant of provisos which qualify the generality of the main enactment. So Arpita, if you could move to the next slide. Right. Now the preamble to I think we've switched around the order a little bit. So if you could just go to the next slide first, which is internal aids to construction, right? So when you are looking at any law, there are things that help you that are inside the law itself, okay? And one thing is the long title of the law. So there's a short title, which is the National Green Tribunal Act. And then this, what is shared on the screen right now, is a long title. And that comes right before, or it's usually with the preamble. So Arpita, if you could show them the preamble that's in the previous and next slide. Right, so this is the preamble of the NGT Act, which sort of talks about how the NGT Act came into being, what the purpose of the NGT Act is, what was really the void it sought to fill, or the remedy sought to bring. And when you're interpreting any word in the NGT Act, it is really, or even when you're doing a similar exercise for the Environment Protection Act, right? So ease of doing business cannot inform how you interpret words under the Environment Protection Act or the NGT Act, right? So the protection of the environment, or the redressal of grievances arising out of environmental damage, pollution, these are the things that should inform how you interpret provisions of the NGT Act. So we could go to the next slide, which, yeah, after this. I mean, I don't, you guys can read this yourself, so I don't want to spend too much time on this. There are other internal aids to construction, such as headings, marginal notes, and illustrations. And it is very important to, every act you'll see will have a definition section, right? And it is the key to solving many ambiguities in the act. It's also important to be mindful of the schedules of an act. Now, especially with respect to the NGT Act, whether the tribunal has jurisdiction to entertain an OA or not under Section 14 will depend on whether the case, the substantial question pertaining to the environment arises out of the enactments provided in the schedule of the NGT Act, which is why this is also something you need to be mindful of. And one more thing is that the General Clauses Act, which is called the Act of Acts, provides a clue to what many terms mean. So this is something that you need to keep revisiting when you're faced with any ambiguity. There are things that are outside of the statute that also help in interpreting it. One of these things is parliamentary history. Now, I should flag here that parliamentary history has had a very checkered sort of history. There's been conflict on whether you should use it, should not use it. The current position seems to be that you can use it to a limited extent to sort of aid you in the process of interpretation, historical facts and surrounding circumstances, and something, again, a very interesting thing called pari materia statute. So if you have a similar statute with the exact same language and courts have interpreted it, then that would also inform the decision of the court when they're looking at something in the statute you're concerned with. And again, as we saw, dictionaries. And I also want to mention the rule of ejusdem generis, which is just because I like it. I think it's a fun rule, which is that words take color from the words that precede them, right? So if general words follow something specific, then again, very context dependent, they may be interpreted to take color from the words that preceded them. So if you have a law that talks about cheetahs, tigers, lions, panthers, jaguars, and other predators, right? And the question is whether this law includes sharks or not, the court could say that while sharks are predators, the words that preceded the word predator are very specific to mammalian land-based predators. So that's how sort of ejusdem generis works. And there are many principles like this that sort of should inform you while you're interpreting the law, or while you're trying to persuade somebody about a particular interpretation.